Well, good morning, friends. This is Gail Strack. I'm the CEO of the National Family Justice Center Alliance, and we are so excited for this webinar today. And just want to say happy Thanksgiving. Thank you all for joining us. Today in San Diego, it's 72 degrees and sunny, and talking to our friends in Minnesota, Stephanie and Marika, it is cold and windy, 15 degrees. So, I just want to give you a big warm hug and hot chocolate. But fortunately, the nice thing about webinars is that we all get to stay in our office, enjoy a cup of coffee, and learn from each other. If you are joining today, I'm sure you are very familiar with the Family Justice Center Alliance. I'm trying to advance the slides, and I think it may be frozen, Natalia. But I will keep on going. There we go. There you go. That's me, Gail Strack. Thank you again for joining us. If you are here, you know about the work of the Family Justice Center Alliance, and you're also probably very familiar with the work of the Battered Women's Justice Project. I think in many ways we are sisters in this work. The Battered Women's Justice Project has done a tremendous amount of work with coordinated community responses. We've taken everything that they've learned, and we have learned from Ellen Pence and others, to try to co-locate, bringing communities together to continue the work under one roof. And as part of our work, we have an amazing team of professionals. I call them tiny but mighty, in the sense that they are a small team, but they have tremendous amount of passion and heart, and together we bring these webinars. And as part of the webinar, our goal is to try to bring important issues to professionals working at family justice centers or in other multidisciplinary teams, to bring in the experts, to bring in some thoughtful conversation to help do the work that we are doing. And I definitely want to give a warm thank you to our sponsor. Thanks to the U.S. Department of Justice and everyone at OVW for making this possible. In particular, we want to give kudos to Bea Hansen, who's our acting director, and Susan Williams, who's been our program manager for many years. We had a chance to see them most recently in D.C., and it's just exciting to see all the TA providers come together to be able to provide great information, also to collaborate together. We wanted to tell you about our International Family Justice Center Conference coming up in San Diego. So if you are in a place where it is cold and windy, think about coming to San Diego where it's 72 degrees and sunny. Our next conference will be at Bayfront Hotel. Our theme for the conference is the root of all crime. We want to talk about the intersection of domestic violence, elder abuse, child abuse, sexual assault, and human trafficking. So we will have even more professionals join us this year. We will have a pre-conference on human trafficking and a pre-conference of our international friends from all over the world who are starting family justice centers, and also our FJC Family Justice Center directors. We are also excited to tell you about our advanced strangulation course. It is only one of its kind. We get 4 days. We go deep and deeper into advanced strangulation. We're going to be talking about how you train professionals, the most recent research, overcoming all the legal defenses, developing your experts to testify, and how you can develop best practices in your community. We also wanted to tell you about our new app and encourage all of you that are listening in today to download it today. As of December 1st, we're going to be charging for it at $129, but right now it is still free. We've been offering it for free to get it to the hands of as many professionals as possible and to try to get as much feedback from all of you to improve it. But so far we've heard great things. In fact, advocates in particular have been using it the most to be able to help survivors document their injuries, so when they are ready to report and document what is happening to them, they have it all down. I wanted to give you a reminder about how to download this webinar later on, especially if you want to share it with your friends or if you want to go back and listen to it, or if somebody in your team didn't get a chance to watch it. You could just go back to FamilyJusticeCenter.com. You can click resources, go to the resource library, and then you will find this webinar. And of course, Natalia, who is here, my right arm, and she's keeping me really calm because we're dealing with a lot of technology, is that she can email it to you. And you have any problems or questions, just reach out to Natalia. She has figured this out. And now it's my opportunity to introduce two of your speakers today, and I am so grateful to both of them. They bring tremendous amount of experience and passion, and most recently I had a chance to meet Marika in Florida, and wow, you guys put together what a wonderful workshop with so many professionals from all over the United States. Well, let me introduce our speakers right now. First of all, Stephanie Avalon. She is a resource specialist for the Battered Women's Justice Project. She gets to respond to the calls, the 911 calls as I call it, from survivors, professionals all over the United States regarding legislation, law enforcement, prosecution, sentencing, and in particular her focus is on advocacy. So she assists in technical assistance. She develops training materials. She coordinates with other trainers. She puts together advocacy trainings, really talking and exploring the role of advocates who are working in the criminal justice system and also in the family court system. So she brings a tremendous amount of experience in the work that she has done, including, you got to check out the website. One of her responsibilities is to maintain and edit the new webpage for BWJP at bwjp.org, where she tries to identify promising practices and brings it all to the website so you can have that information. And in 2012, she hosted a monthly series of webinars focusing on custody issues. So Stephanie comes with a tremendous amount of experience as we talk about the issue of women in the courtroom in 3 different courtrooms of family court, criminal court, and child protective services and juvenile court. We also have Marika. Marika joined BWJP as a technology and communications manager in 2006. And gosh, we would love to have someone like you on our team. In that capacity, she manages the website, oversees the webinar trainings, and manages the infrastructure. Currently, she's involved in BWJP and programmatic work. I need to have some more water here, including organizing trainings and planning curricula for the arrest grantees. She recently completed work as a consultant with the National Witness Protection Center. It was a pilot project in Knoxville, Tennessee. She also serves as part of the technical assistance team at BWJP. Her area of assistance has been in advocacy, especially working with the LGBTQ community and responses to the misuse of technology as a tactic of abuse. Oh my gosh, if you have a chance, I hope people will ask questions about that. Trying to do safety planning when there's technology involved is one of the most difficult things because it definitely changes so quickly. She's also worked as an advocate for domestic violence and sexual assault survivors. So, as you can see, friends, we've got 2 amazing people who can share their experience. So, Stephanie and Marika, I'm going to pass over the controls to you. And Natalia, let's give them a big round of applause. Yay! Thank you so much.
Thank you, Gail, for your introduction and for all the great work you do with the Family Justice Center Alliance. I'm here with my colleague Marika Belgium-Gabbert, and we're going to have a conversation comparing and contrasting features of different court systems. But first, I've got some disclaimers, because language can be difficult sometimes. We will be talking about battered mothers and battered women, but we wish to acknowledge that some women are abusive and some men are victims. In the custody context, however, we commonly see mothers as the victims, and for simplicity, that's the language I'm going to be using. Second, the court where custody is litigated is often called family court. Sometimes we'll be saying custody court and sometimes family court. Courts issuing protection orders differ from custody court in a number of ways, even if, as in many states, they can make temporary custody decisions. We're not talking about protection order courts when we speak of custody court. And finally, the problems we will discuss may not be occurring in your court system, particularly if you're involved in a well-coordinated family justice center with good linkages and communications. If you're fortunate enough to work in such an environment, you must be aware of how special your system is. Marika, can you get us started with some background about the custody problems we're talking about?
Yeah. In a nutshell, what we're looking at is that battered mothers are losing custody to their abusers. Dan Saunders, who's a researcher with the University of Michigan School of Social Work, has written, "Gender bias and the myths about battered women stack the cards against them in child custody disputes. Ironically, their very attempts to protect their children may make it more likely that they will lose custody to an abusive ex-partner." And again, that's highly recommended, Dan Saunders, "When Battered Women Lose Custody, Dangerous Parents or System Failures." All right, so if you Google this title, "Rates at which accused and adjudicated batterers receive sole or joint custody," you're going to find a compilation summarizing a large number of studies which basically add up to this alarming reality. Battered mothers lose custody to their abusers surprisingly often. Another source of research that we found helpful in defining this problem is the Violence Against Women Journal, Volume 11, Number 8, from August 2005. So this journal features research demonstrating several points. So first, how the lack of identification of domestic violence in divorce cases is prevalent and problematic. Secondly, almost half of the cases with a police or court history of intimate partner violence had no mention of it in the dissolution case file itself. They found that battered and non-battered women did not differ on the custody awards that they received. They found that restricted visitation was more likely to be imposed on identified abusers, but only if the court was aware of it. And troublingly, a great deal of documented evidence was actually unknown to the court. So here at the Battered Women's Justice Project, we have taken calls over the years consistently from battered mothers regarding their custody or visitation disputes. In fact, we would say that those types of calls make up the vast bulk of our incoming calls. So as we identified this problem occurring several years ago, Stephanie and our colleague Gabrielle Davis, an attorney working on our National Custody Project, began the development of a curriculum for advocates to help them understand the problems that women are facing commonly in custody court. This webinar that we're presenting here for you today is derived from that two-day curriculum, which is called Advocating for Battered Mothers in Custody Disputes, Linking Abuse to Parenting. All right, so before Stephanie gets started on presenting this curriculum, we'd like to get an idea of who's on the webinar with us today. So would you please, Natalia's going to pull up a poll, and we'd like to know what you all do. So if you are an advocate, an attorney, law enforcement, please select the radio button, and if you're something else, please check other. So I'll give folks a second to send those answers in to us. All right, and I think, Natalia, I missed the, oh, here we go. All right, looks like the bulk of you are advocates at 70%. We got a measly 2% of attorneys, lonely out there, 5% of law enforcement, and 23% of you are something else. All right, thanks for those results. All right, now we'd like to know, in what court system do you folks primarily work? Criminal court, custody court, child protection court, a protection order court, or please indicate whether you're not in a court setting at all, and Natalia will pull that up for us. Again, so we're just looking for information about where you're working. Criminal, custody, child protection, protection order court, or possibly not in a court setting. Giving you a little time to get those answers in.
It's always nice to know we'll be talking mostly to advocates. I feel so much more comfortable.
All right. Okay, it looks like we got some even thirds here. So about 30% of folks in criminal court. We don't have anybody working primarily in custody court. About 36% in protection order court, so this information will be useful for you as well. 30% not in the court setting, and 5% of you in child protection. Thanks for that answer. All right, so Stephanie, can you tell me a little bit about how you and Gabby went about developing this custody curriculum for advocates?
Well, Marika, as you know, I've been an advocate a long time myself, and I came to this work as a survivor. When I started out, there were some basic beliefs that guided how we worked with women. First of all, I start by believing women. I think this is really important. I also believe that women are the experts of their own lives. They have, after all, been living with their situation and trying various strategies over time. I also believe our work with women is a partnership. It's one of the reasons I've never referred to women I work with as clients. The most effective advocacy requires a partnership. I was pleased to see this described in the new edition of Jill Davies and Eleanor Lyon's book, Domestic Violence Advocacy, Complex Lives, Difficult Choices. They write, the depth and sensitivity of the content, often between strangers and sometimes over the phone or through email, must occur in the context of some level of trust, connection, and partnership. People often ask why men batter. I believe battering is a social problem stemming from gender oppression. And finally, raising the consciousness of the women we work with is important to eventually ending oppression. You know, in his book, Why Does He Do That? Inside the Minds of Angry and Controlling Men, Lundy Bancroft says that if you want to help a battered woman, you must be the opposite of what the batterer is. These beliefs represent, I think, not only the opposite of what a batterer would believe about his partner, but are almost universally the opposite of operating beliefs in family court.
All right, so we would like to see whether or not participants on this webinar would agree with the beliefs that guide the advocacy work here. Natalia is going to open another poll, and please indicate whether you agree with each of these beliefs by checking the box next to each statement. And again, in this case, you can answer, you can select multiple boxes. So we'll give you a minute here to answer those. So I agree that these beliefs guide my work. Start by believing women. Women are the experts of their own lives. Our work with women is a partnership. Battering is a social problem. And raising the consciousness of the women we work with is an important part of ending oppression. So go ahead and check any of those, all of those, rather, that you agree with. And we'll give you a little bit of time here to answer those. And when Natalia sees that the results are slowing down, she's going to share those out with us. All right, we've got a lot of agreement. Looks like 96% start by believing women, 93% women are the experts in their own lives, 91% that our work with women is a partnership, 89% at the lowest, battering is a social problem, and 96% believe that raising the consciousness of the women we work with is important. Thank you for sharing those with us.
So with these principles in mind, the two main things we attempted to do in the custody curriculum was to make visible how gender oppression operates in custody courts and prepare advocates to help survivors make it through this oppressive system.
All right, so here's a simple scenario about an assault of a battered mother. This is Judy and Jim. Judy is a victim of domestic assault whose partner, Jim, was arrested last night. She was holding her youngest child, a baby of 2 months, in her arms when Jim threw her down on the bed and struck her across the face. Their 3-year-old child was also in the room when this happened. Judy also has another child, 9 years old, from a previous relationship who was in a different room. Judy has a black eye as a result of this assault. It was not the first assault, but it was the first time that visible injuries resulted. The day after this happened, Judy noticed a red streak in the eye of her 2-month-old baby.
Jim's violence is clearly escalating, and he is violent to Judy while she's holding her infant and in front of their 3-year-old. Also, the presence of a stepchild in the family is a risk factor.
Yeah, but we don't know a lot of other details about the relationship. We don't know, for instance, if Jim has any criminal record, if he has access to firearms, if he is coercively controlling. But in speaking with Judy, she could provide a lot of answers. In this case, we learned that Jim is very controlling about the household money and Judy's time. And he expects to make all the decisions for the family. So taken all as a whole, he does sound like a batterer.
That's right. And the criminal court practitioners have no trouble labeling Jim as a batterer or a defendant, the assailant, the suspect, or the perpetrator. Jim got arrested for assaulting Judy. In many jurisdictions, advocates get information from the police when domestic assault arrests occur, which allows them to contact victims and provide information and support about the criminal process. Sometimes advocates are present in courtrooms, and other practitioners like cops and prosecutors also speak to victims about the criminal process. What are some of the things practitioners will tell a victim like Judy?
All right. Well, when we're in the world of criminal court, and many of you work in this arena, so you'll be familiar with this, Judy is the victim of domestic violence, which is a crime. Battering is the focus in this sphere. She is told things like, no one deserves to be hit. This isn't your fault. Oh, it will only get worse. Jim needs to be held accountable. We are here to help you. And exposure to domestic violence hurts kids. In this area, Jim, again, is the offender, the defendant, a batterer. Prosecutors will almost always encourage no contact between Jim and Judy. And here, as you well know, that proof must be established beyond a reasonable doubt.
In some jurisdictions, cases are routinely referred to child protection whenever officers note the presence of children. Child protection views the same scenario from the lens of child safety. In this case, the children were home, the 3-year-old witnessed the abuse, and the baby was injured as a result of the mother being thrown to the bed with her baby in her arms. How will child protection view this case, Marika?
All right, in the sphere, the planet, the realm of child protection, we see that domestic violence is seen as a child safety issue. And in this case, it's the child who is seen as the victim. So Judy, as the child's mother, will hear, exposure to domestic violence is bad for kids. It's your responsibility, Judy, to protect your children. And you should really think about getting an order for protection to keep Jim away. In this child protection sphere, files are opened in Judy's name, and the case plan is for Judy.
So if child protection opens a case, Judy's now dealing with 2 entirely different court settings. On the criminal planet, she's viewed as a victim, while on the child protection planet, she's now seen as failing to protect for the very same incident. Child protection might even insist Judy get an order for protection to demonstrate that she's willing to protect her children by keeping Jim away. Finally, here's the custody planet. From the scenario, we have no idea if Judy is planning to split from Jim. But if she gets an order for protection, or if the criminal court issues a no-contact order, it wouldn't be unusual for Jim to take some action on his own. If the couple is married, he may file for divorce. A criminal no-contact order might make it necessary for Judy to apply for financial aid. This could trigger a paternity action, which could also be an avenue for court-ordered parenting time. So landing on the custody planet is highly likely. Marika, what will Judy find on the custody planet?
All right, well, in contrast to the criminal court or protection order court, where battering is the focus, or battering is used through the lens of child safety, in this court system, what we see is that battering is very invisible. The best interest of the child is the goal of the court, and there is an underlying assumption of equal access by both parents. Violence against Judy is not necessarily viewed as even relevant to parenting, and Judy will hear messages such as, let's focus on the future, or every child needs 2 parents. Mediation will result in better decisions. You're going to still need to co-parent. He's still their father, and the marriage may be over, but parenting is forever.
So if we put all the planets together, we have the 3 planets model, which was first discussed by UK researcher Marianne Hester in 2004.
So the calls that we receive on our 800 line frequently involve battered mothers who are caught up in 1, 2, 3 of these systems. And I always think when I speak with them that this must make you crazy.
Yes, it really does. I experienced myself that a long time ago when I mentioned I'm a survivor. I was in an abusive marriage. many years ago, in the late 1980s actually. The violence started as very minor incidents, but when it reached a point where I realized I was indeed being battered, I looked up services in the phone book and contacted an advocate. She told me the assaults were crimes and that my husband could be held accountable. And notice that the language, it always comes from criminal court in this kind of a context. When advocates talk to women about domestic violence, they really emphasize the criminal aspects of abuse. And there's a lot of good reasons for that. Through the advocate, I learned I could get an order for protection, and I chose that option rather than calling the police because I didn't want to involve police, and I naively thought that my husband would stop his abuse. My original order didn't even exclude my husband from my home because I thought he would be reasonable, recognize the violence was simply wrong, and stop. The advocate knew better and had prepared me to call police if I needed my order enforced. I really was shocked how soon that was. 2 days after getting my first order for protection, I called the police for the first of many times. I then modified the order for protection to exclude my husband from the house. Visits with the children were set up through the protection order court as supervised. My advocate advised me to report my concerns about the children to Child Protection and offered to go with me as well. Child Protection agreed my concerns were valid. Among the things I shared with them was an assault similar to the story about Judy and Jim. Child Protection said, as long as something really bad doesn't happen, keeping his visitation supervised would be sufficient and they didn't need to open a case. Over the course of that first summer, I had over 70 calls to the police, which eventually resulted in 4 misdemeanor charges. Meanwhile, my husband initiated divorce proceedings in family court. He was, no surprise, seeking custody of the children. The divorce and custody matter involved an endless succession of court hearings as my husband brought motion after motion. It went on for over 3 years. While I was continuing to keep my husband's access to the children limited and supervised, my divorce attorney repeatedly warned, you can't keep his visitation supervised forever. Nothing really bad has happened. He is still their father. I became increasingly worried. So I asked Child Protection if they would assist in family court to get the supervision ordered as part of the final divorce order. They declined. Eventually, a visitation evaluation was ordered, which came back with a recommendation that my children's father see the children supervised at the rate of 4 to 6 times a year. My attorney thought I had won, but I wasn't so sure. I wondered what he would do now that he seemed to have run out of legal options. I found out one dreadful January night when my daughter was 2 years old and her father broke into my home while I was asleep in violation of the current order for protection and painted my baby's back and buttocks with silver nitrate in an attempt to frame me for child abuse. Silver nitrate in small doses on adult skin discolors in a way that can look like bruising. On my 2-year-old's baby skin, it caused third-degree burns, penetrating all layers of the skin and leaving horrible wounds that literally took months to heal. Something really bad had finally happened. By this time, I'd reported concerns no fewer than 4 times to Child Protection. In addition, a man who belonged to a group of dads who felt they were unfairly treated by child abuse laws called in to report to Child Protection, warning them that my husband was about to commit this crime. He'd been asked to assist. What he didn't know was that when he refused to help frame me, my husband went ahead with his plan a day sooner. So Child Protection had just gotten the report of this assault when the man called to warn about it. He later testified at the criminal trial, and the prosecutor said his testimony was critical to the conviction. Despite my earlier pleas for help from Child Protection, they initially viewed me as the prime suspect. My 2 sons were taken from me, and they tried to separate me from my injured daughter as well. Even after my husband was charged with first-degree assault, convicted, and sentenced to 90 months in prison, Child Protection still wanted to continue monitoring my parenting because I had failed to protect my child. They told my advocate, the bottom line is she married the guy. My divorce and custody case finally came to court after my husband was sentenced and in prison. And some months later, I succeeded in getting Child Protection out of my life. I was finally able to move on. So that's when I became an advocate.
I guess so.
This was a long time ago, but all the differing messages I got from the court systems that I used never really made sense to me until I read Mothering Through Domestic Violence by Lorraine Radford and Marianne Hester. They describe how the courts are so different they might as well be three planets. But there are other differences distinguishing criminal court from custody or family courts, and these are some of the insights that Gabby brought to our curriculum. Family court has undergone major transformations over the past few decades. A gradual decentralization and privatization of functions, outsourcing to private, non-judicial actors. What was in the past a process that was wholly contained within the walls of the courthouse has become a process that exists almost entirely outside the confines of the court. Parties could once expect that their claims would be heard by a judge and decided on the evidence. Now they encounter a system that's more or less blind to their legal claims.
Well, that certainly sounds like what our callers are experiencing. What do you think is behind this?
Well, lots of things, including mounting caseloads, diminished institutional resources, criticism of the adversary system. Most of the work that goes on in the typical custody case occurs outside the court itself. From an institutional perspective, Gabby noted a number of glaring problems. Over the past 30 years, advocates and others have done much to improve how the criminal system responds to domestic violence through the development of coordinated community responses, CCRs. Family Justice Centers are a kind of CCR. In these CCRs, law enforcement, prosecutors, probation officers, and others join forces to enhance victim safety and offender accountability. Though by no means perfect, advocacy within the criminal justice system has improved exponentially, and our ability to effect positive change has grown as CCRs have become more sophisticated and more responsive. We can't really say the same thing about the family court system. That's due in part to the contrasting hallmarks of the criminal and family court systems. These hallmarks are described in a child custody differentiation project progress summary, which is available on our website, and this is the page that you'd be looking for. And right where it says, when you go to this page, you go to where it says click here, and if you want to read more about it. And I will describe some of these features here. The criminal system, first of all, is composed largely of state actors, police, prosecutors, probation officers, child protection workers, and in many jurisdictions, victim witness staff are more or less official arms of the state. Their authority is constitutionally or statutorily defined. The law tells the police and the prosecutor what they're authorized to do. The police officer knows he's authorized to make an arrest upon probable cause. He also knows he's not authorized to put on the state's case, because that's the prosecutor's job. All of that is defined by law. On the other hand, the family court system is comprised mostly of private, independent actors, like mediators, guardians ad litem, court-appointed special advocates, attorneys, custody evaluators, and parenting coordinators. Our criminal justice system has clearly defined constitutional and statutory limits on the authority of state actors. The police, for instance, may not conduct an unreasonable search or engage in excessive force or compel a suspect to incriminate himself. The prosecutor may not deprive a defendant of his right to confront witnesses or withhold exculpatory evidence. In family court, independent actors do not function as an arm of the state but operate as private citizens. Their authority is not constitutionally derived but purely discretionary. If the state actor exceeds his or her authority, the law provides a remedy, at least in theory. So people who are drawn into the criminal justice system enjoy certain constitutional and statutory protections from government overreaching, and that's really important. Family court professionals, on the other hand, act outside of the Constitution, which means that litigants enjoy few, if any, meaningful protections from overreaching. Most family court practitioners are self-regulated. They're mostly in business for themselves and not governed by law, but by professional standards that are largely created and overseen by the professions themselves. Criminal court is characterized by relatively clear chains of command. A line officer is accountable to her commanding officer, and an assistant prosecutor is answerable to the chief prosecutor. If we need to implement a new policy or protocol in the criminal court system, we call the chief prosecutor or the sheriff or the chief of police. And assuming they agree with us, they can issue a directive from the top that everybody below must follow. If the chief discovers that her directive isn't being followed, she can discipline those who fail to comply. Again, at least in theory. But since most family court professionals are independent agents, if we want them to adopt a new protocol, for example, we have to convince each individual mediator, every lawyer, and each individual evaluator to change his or her protocol. There is no chief mediator, head lawyer, or chief custody evaluator to whom all others must report. In the criminal system, standardized work practices are established to ensure that every worker handles his or her job in similar fashion. A 911 operator cannot show up to work one day and simply decide to reinvent her job. Standardization ensures that what one particular 911 operator does is essentially the same as what every other 911 operator does. The same isn't true for practitioners in family courts. These practitioners have almost unfettered freedom to reinvent their jobs as they go along, to decide for themselves how they're going to approach each case, how they view their roles and their relationships to the parties, what information they think is important, and what information they'd prefer to ignore, and what priorities they choose to establish. With limited exceptions, most of what happens in the criminal system is on the record. For example, the police generally cannot conduct a search without a warrant. The prosecutor can't establish proof beyond a reasonable doubt based on information that hasn't been offered into evidence. With few exceptions, the things happening in criminal court are supposed to be on the record so an appropriate review can be conducted if it's needed. By contrast, a significant amount of work in the family court occurs off the record, in the dark, behind closed doors. Non-judicial family court professionals are not constrained by the rules of evidence or the rules of civil procedure, and there is little opportunity for parties to put on a case, much less challenge inaccurate, unreliable, or misleading information. Closely related is the issue that most decisions made in criminal court are appealable. If a criminal defendant believes there wasn't probable cause for his arrest, or that his conviction was based on inadmissible evidence, or that the terms of his sentence amount to cruel and unusual punishment, he has a right to appeal. In contrast, if a party to a custody action doesn't agree with a family court practitioner, with what's contained in a custody evaluation report, for instance, or with the way mediation was conducted, there is no efficient way to challenge the process, or correct misinformation, or complain about the result directly. While she or he may appeal a decision of the court, in order to prevail, she or he must show that the judge committed some error. An error committed by a non-judicial actor ordinarily cannot sustain an appeal. Yet the work of these non-judicial practitioners is highly influential. Custody evaluators will often tell parties, "I am the judge," because they know their reports are seldom challenged. Finally, as mentioned already, the criminal justice response to domestic violence has become increasingly more coordinated. The system as a whole has come to recognize the importance of a well-organized CCR, and communities across the country have embraced this fundamental principle, which is reflected in criminal justice policies, protocols, and training. The services performed by family court professionals, on the other hand, are largely uncoordinated. There are few linkages in place that encourage or even allow family court practitioners to engage with one another in any kind of genuine, productive, non-adversarial manner to promote the safety and well-being of battered mothers and their children. Institutional hallmarks of the criminal system have made it possible to advocate for enhanced victim safety and offender accountability. But the family court system still has many advocacy challenges.
So the work of our National Custody Project has confirmed those earlier studies we mentioned that show that decisions made in custody cases fail to account for violence and control still present that's still impacting the safety and well-being of mothers and children. We've seen that custody courts permit very little in the way of due process and that they often fail to account for violence. So what is it that's driving decision-making if it's not the actual facts of the case?
Well, one explanation is the problematic discourse we discussed earlier in the webinar, the messages people hear in family court, how practitioners think and talk about custody.
Okay, I think we need to define discourse here because that sounds like an awfully academic term to me.
Well, indeed it is. Discourse. The way people think and talk about something, the concepts, theories, and assumptions that guide our actions, beliefs, mental shortcuts that are created through professional, religious, political, and/or social training or upbringing. Discourse is present in most professions. In the criminal system, examples of discourse include terms like mutual combatants, which implies some sort of equality, which often is not really present in domestic violence cases where both partners use violence. Dual arrest is another way of speaking about this that's perhaps not quite as loaded. Discourse is often language whose meaning contains some hidden assumptions. And some of these assumptions and beliefs are embedded and largely invisible. They seem self-evident or natural to people whose decisions are guided by them, and they filter out annoying facts that don't fit. Remember the 3 planets we talked about earlier and the messages Judy was getting from family court? These messages are expressions of deeply held beliefs and assumptions. And these beliefs and assumptions almost invisibly guide decision-making in family court, often ignoring evidence. 3 new studies shed some light on the relationship between what family court professionals think and believe about domestic violence and how they act on these cases. Why does discourse matter? Saunders wanted to know how evaluators' beliefs about intimate partner violence are related to their custody recommendations. So the first piece of research that we're going to look at was conducted by Daniel Saunders, who we quoted earlier in the webinar. He's with the University of Michigan. And it's called Custody Evaluators' Beliefs About Domestic Abuse in Relation to Custody Outcomes, and it was funded by the National Institute of Justice. And this research essentially says that evaluators' beliefs are more closely associated with their parenting recommendations than the actual nature, context, and severity of abuse they observe. He used 465 respondents from a national survey. He used vignettes that showed either serious violence, coercive controlling behaviors, or mental health issues. And he looked at respondents' beliefs about false allegations, alienation, the relevance of domestic violence to custody, and the harm to children resulting from parents' resistance to co-parenting. And he correlated those beliefs to certain core beliefs about patriarchal norms and values, social dominance theory, which is that inequalities in life are natural and desirable, or a just world theory, which is essentially that good things happen to good people and bad things happen to bad people. And what he found is that on identical facts, evaluators came to radically different conclusions. When it came to custody recommendations, about half recommended joint custody and about half recommended sole custody. When it came to access, about 1/3 recommended supervised visitation by a family member, about 1/3 recommended a professional supervision, and about 1/3 recommended no supervision. Saunders' research suggests that the difference is evaluators' beliefs. Marika, can you tell us about Hardesty's research?
Yeah, so Jennifer Hardesty took a look at how evaluators' beliefs about domestic violence influence their custody recommendations and their assessment of a mother's credibility. So in her study, and she's at the University of Illinois at Urbana-Champaign, in her study she took 600 respondents from 48 states and gave them a 3-part vignette with randomly varied facts. And what she found is actually that the mother's demeanor itself is more closely associated with the evaluator's recommendation than either the severity of the violence, whether it be mild or severe, the type of violence, whether it's conflict versus coercive control, or whether it was documented.
A New York study based on actual case reviews of about 70 family law custody files is our final piece of research that we're going to look at. In this case, in each case, domestic violence was pre-identified. Each party was represented by an attorney. A custody evaluation was conducted in each case, and the researchers looked at all of the documentation of abuse, each of the custody evaluation reports, and the final judgment or settlement agreement in each case. They found that evaluators' knowledge about domestic violence, the awareness of risk factors, and application of a power and control model is more predictive of their parenting recommendations than either the severity of abuse or the thoroughness of their investigations. Taken together, the research seems to say that what's going on inside the evaluator's head, that is, the evaluator's knowledge and beliefs about domestic violence, have more to do with the outcome of the case than what's actually going on in real life. And note that in these studies, they show not only how discourse can hurt battered mothers, but also how it can actually help in custody cases. For example, in this last one, that if evaluators have more knowledge about domestic violence, they would have more favorable custody, or more what we would view as more appropriate custody recommendations. A number of years ago, I asked an advocate, a very experienced advocate, to think about characteristics common to battered mothers with complicated custody cases. And she came up with a list of 10 things that we just call red flags. And they are basically that the woman has a history of chemical abuse, or the abuser alleges that she has a chemical abuse problem, that the woman has a mental health diagnosis, or again, the abuser alleges she has, that there's been a history of court filings to modify parental access times or custody or visitation. Or a woman might file a petition for a protection order at about the same time custody is being disputed. If she alleges that he abuses the child, whether physical or sexual. If she alleges that he abuses her. Next slide. The child has significant developmental issues or health problems and the parents don't agree about it. She has had one or more relationships with abusive men. System practitioners view her as difficult, regardless of whether she has a significant parenting deficit. And finally, the abuser has threatened that if she left, he would get the kids. So how we initially used this list was simply to help us recognize trouble when we were speaking with women about the custody situations. If you heard one of these factors, you know, it would just help you pay more closely attention to what was going on. And sometimes you could even say to somebody on the phone, you could predict the next thing, like, has he gotten custody already? Because if you hear enough of these examples, you probably know what kind of case the woman is dealing with.
Yeah, I remember these red flags from way back when Stephanie was first training me in as an advocate answering calls on our 800 line. And I remember thinking that some of them seemed really strange. You can kind of understand how if a woman has a substance abuse problem or that it's alleged that she has, where it may create some problems in the custody arena. But other of them don't make much sense. For instance, just the mere fact of revealing domestic abuse. Why would that be a flag for a bad outcome? Is it because people believe that women are, you know, using the revelation of abuse to gain the system? Here we have a red flag for trouble when you hear that. What is, in your work with this curriculum, what has shed light on this apparent contradiction?
Well, actually, when we thought about this, examining the thinking about the beliefs operating in family court, you can see why some of the red flags can become traps. Why should it be so problematic for women to try and get an order for protection in the middle of a custody dispute? One explanation is the default assumption or belief of many family court practitioners that in a custody context, trying to get an order for protection is somehow an attempt to manipulate the system, or as people often say, get a leg up. So if the default assumption of family court practitioners is that the woman is lying about the need for protection and trying to gain some unfair advantage, that certainly puts her in an unfavorable light.
But maybe there's a good explanation for this. For instance, the mother doesn't actually want an order for protection, but filed for one on the advice or the serious advice of police, child protection, or advocates. Or perhaps she simply experienced violence and actually wants protection.
Yes, and there are probably other realities as well. But we have several more examples like this. What if the mother has sought professional help or treatment for mental health providers, from mental health providers? Practitioners will assume the mother's crazy.
Or, reality check, maybe the mother is actually mentally ill, but it is controlled and doesn't pose risk to the children. Or perhaps she's not mentally ill and has simply sought help for symptoms related to the abuse and trauma in her life. All right, this is an interesting one. What if the mother has had one or more relationships with abusive men? So the default assumption by family court practitioners would be that the mother is somehow asking for it, or it's her actual poor judgment that's the problem here.
Yeah, I mean, I think that's where child protection was coming from when they said to my advocate, she married the guy.
Right, right. That's discourse right there. She married the guy.
The mother's partners perhaps didn't reveal abuse initially, but it escalated over time. It's also possible that the mother's partners have good qualities that she thought outweigh the abuse.
This one is a little perplexing. So this is a red flag we've seen. The mother believes that the child has significant developmental issues or health problems, but the father doesn't agree. So again, we see the default assumption of family court practitioners is that the mother is lying about the problems or somehow exaggerating them for some unknown reason.
But it could be that the mother is mistaken about the child's developmental or health concerns. Or it also could be that the child does have significant problems, but it's the father who fails to recognize them.
So one other red flag is the history of court filings to modify parental access, times, custody, or visitation. And the default assumption of family court practitioners is that this is a quote-unquote high conflict case, and we hear that a lot.
Yes, we do, but it could be very easily that the plans have not been workable as they fail to account for the abuse. It's also possible that litigation abuse is going on, and litigation abuse is like, you know, the endless bringing back to court with motion after motion after motion. So in conclusion, beliefs, not facts, are guiding lots of decisions in custody cases. Beliefs are difficult to change, but it's not impossible to change them. And you can help this process of change by challenging assumptions about battered mothers. In our community, for example, it's been very difficult to get supervised visitation ordered for batterers because guardians ad litem believe that waiting lists that could mean visits would be delayed by weeks or months are viewed as inherently damaging to children. They think that it's really important to establish access right away.
Wasn't that interesting? In our time of ongoing war, we don't hear many people worrying about the absence of fathers when men are, for instance, deployed to a combat arena in which they might have an extended period of separation. This is an example of a comment that can challenge that framework that asserts that mere separation from fathers is actually inherently damaging.
The vast majority of battered mothers want their children to have contact with their fathers. Given the huge cultural beliefs about the importance of fathers when battered mothers ask for help protecting their kids, please start by believing them. Women are just as much a product of culture as everybody else. By the time a battered mother gets to custody court, she's well aware that society believes strongly in the importance of fathers in children's lives. It takes a lot of courage to go against that norm. Mothers trying to limit paternal access are facing a very difficult struggle, and they would not take it on if they didn't have good reason or if they didn't think they had good reason. So I think the least practitioners could do is to start to try and believe them. And we'll take questions now, and this is our contact information. You're welcome to call us on our 800 number. We have our phones staffed every workday. Every workday we're here. And and you can contact us via email as well.
In addition to speaking directly with victims of battering or domestic violence, we also work with practitioners. So if you're a practitioner in the family court arena, in the criminal court arena, and you're struggling to deal with these issues, we have attorneys and advocates who are available to think through and strategize and commiserate sometimes is what we can do. But we're very happy to talk to people via our 800 number.
Have we had any questions?
Well, thank you. So this is Gail. Thank you so much for your presentation. What I'm going to do right now is encourage our attendees to send in their questions. We certainly recognize that every court is different, every state is different, every community is different, that there are advocates out there who have tremendous amount of experience. We definitely want you to share your experience, send in your questions, or if you are working in a jurisdiction that is handling this well, let's brag about people. Let's brag about some solutions. And ladies, while we get those questions, there's a couple of comments I want to make. First of all, I thought your presentation was great. I certainly appreciate your time and your experience. It's rare that you get the chance to kind of hear, like from the front line, what calls you are receiving. So thank you for sharing that. I also appreciate the articles that you shared in your presentation. I had a chance this morning to read through some of them. I definitely like Mary Ann Hester's article, and she does make the case of what survivors need from all of us in coordinating our response in criminal court, civil court, and juvenile court, and recognizing that our worlds are very different and that our cultures are very different, which makes the business case for a CCR or a family justice center. And today, as you were talking about some of the issues, I couldn't help but reflect your point about domestic violence disappearing, and it's sometimes not accounted for in the courtroom. And I think my reaction to that is to encourage those that are listening in to document. I think that's one of the reasons we created the documentation app for strangulation. But as a former prosecutor handling these cases, I also worked in juvenile court and civil court, that the documentation is critical. So the more advocates can do to encourage survivors to document, the better they will be. There's so many different reasons why battered women need this information. You can just probably have a whole list of reasons they can need it for housing, obviously for immigration issues, and the list goes on. So Stephanie, I don't know if you want to comment on why victims need the documentation.
Well, they do need the documentation. The other thing is that lots of times, I spoke to a woman just recently who said that when she was first dealing with the abuse issue, a police officer said, "Do you want to press charges?" And she thought, well, how would that help my children to have their father arrested? And then later on, in the custody case, she wasn't believed. And had the arrest taken place at the time, had there been adequate documentation, she might have been able to get people in family court to actually believe her. And it's one of the, so that if you're working with women in a criminal court setting and they have children, it can be a persuasive argument to, this could be a case that you can actually prove beyond a reasonable doubt. And if you've got that kind of a case and you go forward and get it documented, you're going to stand a better chance of having the family court recognize that domestic violence really was a problem.
Thank you, Stephanie. And we recently realized that very point ourselves. A few years ago, we started a legal clinic at our San Diego Family Justice Center, and we tackled the restraining order clinic the same way we have done in years past. One of the things we've learned is exactly what you said. On the day of court, judges are going to have two nice people because they're all cleaned up, ready to go, and it's going to be hard for judges to make those decisions, and you need the documentation. Fortunately, working in collaboration and coordination, much like Mary Ann Hester pointed out in her article, you can share more information, and I'm grateful to the San Diego Police Department, Alexia Peters and Pam O'Leary, in that collaboration where when a victim walks into a family justice center and they ask what brings you here today, and she responds to get a restraining order, she can get a copy of the police report within 15 minutes or less. She also has access to the photographs of any injuries and so much more. We have trained our entire team to think about these cases much like a police officer investigates it, and to bring that forward to the court. And we have seen at least a 25% increase in the number of temporary restraining orders that are being granted, as well as the permanent restraining orders. So I can't emphasize enough the documentation. The other thing that I kind of landed with me when you talked about the research related to the evaluators and their knowledge and their beliefs. And I thought, oh my gosh, this is a great time to make sure that in our mailing list, when we have trainings, whether at your CCR or Family Justice Center or working with your domestic violence counsel, that we make sure that we have those evaluators on our training invitation list. Oftentimes they're in, like you said, another world and another planet, and we just need to invite them to make sure. Most recently I had a chance to go to our court meeting and realize that we did not have them included in our mailing list and that we needed to, because this is our chance to educate, and let them know what our survivors are experiencing. So that was something that I felt was a really good point. The other point that you guys made that I loved was about the demeanor. Whether as a former prosecutor or working in any other court setting, demeanor and how victims come across is going to be very compelling. And by the time survivors come forward, they can present themselves in a very angry, frustrated way. So we have found whatever you can do to support victims of domestic violence, it's going to help with court support, with advocacy, and court preparation, so they can anticipate what's going on. Because the courtroom, as we found out in many, many focus groups, is that it can be a very scary place. And we need to have more advocates to support victims in the courtroom to navigate what is happening and to make them feel more comfortable in what's going to happen in the courtroom, how do they present themselves, how do they dress. And speaking about dress, if you have the opportunity to partner with Dress for Success, it is definitely a good way to help survivors feel good about themselves, to have brand new clothes to go into the courtroom as part of your protocol and how you prepare survivors to go into the courtroom. So having that discussion, we now have a couple of questions that have come in. So ladies, I'm going to go right through. We've got about 4 of them. This comes from an advocate who works at a shelter, and she would like to hear from you is how do we help the women that come in with children? So Stephanie or Marika?
Well, there's lots of ways to help. There's lots of ways to help women with children. The children, of course, are sometimes shelters have children's advocates as well as women's advocates, and that can help a great deal. I think it's important for women who have children who are in shelter to be aware of how the court is going to be viewing them differently. I mean, that's why I talk about this three planet, because it's very confusing to assume that you're going to be believed in one setting where you're not. And even sometimes in criminal court, women aren't always believed, depending on how much evidence they have or don't have. So, so I would try and help women understand that there could be a conflict about custody in the future, and that sometimes it's really important to have the documentation at the start.
Yeah. We see that, you know, women, by the time we always say that by the time you're calling an 800 number, you're generally in very deep trouble when you're calling 800 numbers for help. And one of the things that's very surprising is how shocked women are that this even could possibly, that it could be even in the realm of possibility. They've, you know, even when they have done documentation or they've gotten an order for protection or they've had their partner arrested, they've participated in the process, as asked, they still are sometimes, and we're surprised and shocked and dismayed as well, but they're so shocked by the fact that they've done all the right things, all the things the system has asked them to do, and they still end up in this position. And So if you're in a shelter setting or you're working with women on the front end before these things have happened, you don't want to scare them about their children, but letting them know that this has happened to other women is certainly something that we think is very important and valuable information that they should be armed with.
And I think that shelters could do an enormous service by specializing their support groups for battered mothers who are actually involved in custody disputes. Support groups can be tremendously helpful for battered women, but they're most helpful when they have groups of people in similar situations. So a specialized support group for women in custody disputes goes a long, long way towards helping these women. And some of these, there's a couple of models. And in fact, if you're interested, there's 2 webinar recordings on our website that address this issue. One is a support group that has no curriculum and is very loosely conducted. It's been going on for about 10 years with some women who've been with it for a long, long period of time, because it goes on for a long period of time post-separation. And the other is a group, is a Duluth curriculum that's called Strong Moms, Safe Kids. And their curriculum works with the mothers and children together and with them separately. And what it's trying to do is help kids who are having to visit with dads who are difficult and abusive, giving them some tools for taking care of themselves, and also helping the mothers to realize what they can and can't get too worked up about. That, okay, this is basically just typical abuse behavior post-separation. And the Duluth Project has recently come up with a new power and control wheel that talks about post-separation abuse. And if you look that up under
the duluthmodel.org,
you can find that new power and control wheel. And this is a really useful way of helping mothers work with their kids and understand what's going on. Because batterers typically, post-separation, will use their children in a number of ways to get at the mothers.
And I think this is something that we as advocates have not necessarily been as on top of addressing. We are often emphasizing, get out, get safe, but without acknowledging that the very real situation that women will find themselves in, we really are doing women and victims a disservice.
Yeah, the system is going to insist that you have some contact.
Right, in the vast majority of cases, right.
Okay, well, thank you. Some of your answers actually answered some of the questions that we've been receiving. So I'm going to move on to another one. Another question has to do with documentation. What happens if the court refuses to review it? How can that be addressed? I know in San Diego what we've done, because we have experienced that, is that by including the documentation as part of your temporary restraining order right up front has really increased the amount of cases that are being granted, but it also forces the judge to review the entire application. We found that before we changed our policy that many times the judge would not review any attachments because you did not comply with court rules by having certain evidence provided to the respondent or the opposing party. So they would be excluded based on technicality. So I don't know what your experience has been and how you would advise some of our listeners and how to encourage judges to review the evidence that's being attached or provided to the court.
Well, this is a question that I think is of more of a legal nature. As an advocate, I really don't know how you can get that evidence looked at, how you can force anybody to look at it. I mean, what we hear from people all the time that things are being ignored, that evidence that they've had, even when they have attorneys, and it's also problematic that a lot of people are going to court in custody matters without attorneys. Sometimes they start out with one, but by the time the case is dragged on for 2 or 3 years, they may have run out of any funds if they had them in the first place, and they're representing themselves. And so it's really, really problematic how to address this. And basically it's a question. It's really a question for attorneys that are working in the jurisdiction.
Thank you. And I think I certainly learned a lot from Casey Gwynn when I started practicing as a prosecutor, and we had that problem in criminal court early on. And we found by doing trial briefs, really understanding the rules of evidence and the case law, and summarizing everything for the judge. So if you have an attorney, I would definitely encourage that the attorney write and draft a trial brief, points and authorities, why the court shall or should consider this evidence. I think just litigating and arguing about it forces the judge to consider the evidence whether they like it or not. And if you're without attorney representation, our recommendation is to attach as much evidence as possible right from the beginning when you file your application for the temporary restraining order. We have found those techniques to be very successful. And speaking about attorneys, the other question has to do with advice, because one of our listeners has pointed out that she or he is seeing a lot of litigation happening in their jurisdiction, and how can that be addressed in our courts with attorneys representing the clients? Obviously, this may be driven by the respondent or the batterer, who might have means to litigate, much what you represented and shared with us, Stephanie, that this can go on motion to motion, year to year, and they're just relentless about it. But have you found any solutions or tips to address the litigation in court?
Well, one of them would be, of course, to file a motion of some kind to ask that the abuser pay for the attorney fees. It can stop. I mean, I've heard of cases where some of the abuse has stopped because it began to be too expensive. But sadly, some of these people that use litigation abuse, they often have unlimited resources, or or connections to people that are helping them, fund their case. So it's a pretty big problem, and it is a problem primarily that's one-sided, because a battered woman who has gotten a divorce matter settled, and the guy has perhaps some access time that's been recommended. She's not in a position, if he doesn't use his visitation, she isn't going to take him to court and force him to. She can't do that. But she's constantly at his mercy, that if on any whim, he can take her to court. If she doesn't follow what he thinks is important to follow. If she, sometimes it's retaliatory for seeking an increase in child support. And so it's a really big problem. And right now, there isn't a lot in the way of useful solutions to it, although, again, increasing judges' awareness about how this works and how, what I'm hoping that that a widespread understanding of the post-separation tactics might help inform practitioners to the point where you could present, because a lot of the stuff that goes on post-separation begins to look very petty if you just look at it individually. There's a lot of harassment that goes on post-separation from abusers, and an individual instance of harassment can sound fairly trivial, or it sounds like a laundry list of things. And I'm hoping that by categorizing things in the different categories of post-separation, like relentless harassment, like turning the children against their mother, setting up situations so that the mother is discredited in the community, all these various tactics that are being used, financial abuse, and so forth. I have been advising women to categorize the things that are going on so that they fall within those post-separation tactics. And I'm hoping that it'll begin to make more sense to judicial officers if they start recognizing that that it's a constellation of problems that are characteristic of batterers post-separation.
One other thing that we've heard about during the course of our National Custody Project is attorneys for battered women filing motions to stop excessive motions by the opposing party. And we hear limited stories, but we'd be interested in hearing if any of you out there are using anything effective to stop litigation abuse, because this is an ongoing large problem throughout the country.
It really impoverishes women, and it's also very difficult to get on with your life if you never know when you're going to be called back to court.
Well, thank you. I think you've raised some really good points, and I definitely agree that it really does come down to educating the judges as much as possible about litigation abuse. And that's where I think we can help with encouraging the evaluators and all the participants in family court to attend training, and for the attorneys representing the survivors to include some of that information in their pleadings, either through taking notice of some of this research that's out there and or calling experts. As we're starting to wrap up, there's one last question related to restraining orders. And one of our callers or attendees says that in her jurisdiction, they are dealing with issues that they've got the restraining order, and the survivor calls the police to try to document the violation, but sometimes the police do nothing about it. They see it as, well, it's not that bad, and there's nothing we can do about it. So she wants to know is, how do we get the police to respond appropriately and hold them accountable for the violation of the restraining order? And I know, as from my perspective, I certainly got my points, but hopefully we can share both. I really want to comment and commend the work that BWJP has been doing with Ellen Pence and others in Blueprint for Safety, because in the Blueprint for Safety model, you really do take a look at the different systems to find out how you can collaborate. And I think this is also where high-risk teams and multidisciplinary teams, when they do risk assessments, can really be helpful, and where domestic violence counsel have a law enforcement committee where they can bring this. I've also seen court watch programs be able to address this, encouraging victims to bring this information to someone as an advocate or a civil attorney so they can take it up the chain of command. When there is a complaint to a police department that somebody's not following their law enforcement protocol, that has to be addressed. And I think it is our responsibility to hold each other accountable when the system fails survivors. So ladies, any other tips you have found that are really helpful in this area?
Well, we get actually calls from people who are having that sort of an experience. And what I usually tell women is this is where I suggest they get an advocate to go with them to the police department, to write the police report, and to go and get that police report taken to a prosecutor. What I didn't know when I was going through my own situation, calling police endlessly, it seemed like, I had no idea why nothing was ever happening. In the end, there was a cop who finally said to me, you can't just keep calling the police. And I just thought you make a police report that it automatically goes somewhere. Well, it doesn't always. And just like in the situation you're describing, it doesn't always happen that police are going to follow what they're supposed to do. But you can go, if you go with an advocate to the cop shop and ask to make a police report, you'll have something that you can work with. And I encourage women all the time to use advocates to talk with practitioners. I never want them to go to a police department without an advocate. I just think that's asking for trouble. And or even to talk to a prosecutor. I think it's really helpful to have an advocate with you, because you don't know whether you're going to talk to somebody that's sympathetic to the situation, like you are, Gail, or some sadly are still somewhat hostile.
Right, and hopefully the advocate in your area has formed those relationships as a part of a coordinated community response, so that they have some past relationship to fall back on. If that's not a place where your community is particularly strong, we would encourage you to continue to work to build those relationships, because it's those very situations that can really concretely benefit victims when in an instance where orders for protection aren't being enforced.
Okay, well, thank you so much. I think we're now at the end of our questions. I just want to again thank you both for sharing your time, your experience, and giving us a really great presentation and so much to think about. We are excited as we are reaching out into the future, reaching out to Sarah Buell, Nancy Lemon, and the American Bar Association on the Commission on Domestic Violence. This is a very important issue, and our hope is to bring different thoughts and ideas and other great thinkers to the table to continue this discussion to find out what are other jurisdictions doing, what are some of the best practices model, what can we do to encourage attorneys to be able to handle these cases as a promising best practice. I do want to share with those who are still online is that recently we modeled a program from New York. Our program here is called the Center for Solo Practitioners, where attorneys who have just passed the bar are working in a sort of like a residency program. We have them co-located here with us at the Family Justice Center Alliance. And they're an amazing group. The first group was 10 attorneys from different walks of life, with different expertise. Some are family law attorneys, immigration attorneys. We have criminal defense attorneys, and they've all received training in domestic violence, child abuse, sexual assault, dynamics, interviewing, and they have served as like a small army to support survivors, because as we've been doing this work, we realize that civil legal services is the #1 requested item in most family justice centers, and there's just not enough. So whatever you can do to partner with solo practitioners who are eager and excited to learn as much as they can, you do create a workforce that is very sensitive to this issue. We're excited that our first group decided to stay, so we will be welcoming 10 more attorneys to join us, and they've all pledged to provide pro bono and low bono hours to support survivors at the Family Justice Center to be able to increase the access to civil legal services. Because as you ladies pointed out, many of the survivors are still going into court unrepresented, and we see many of those same survivors who are not represented by attorneys, where the respondent does come in with an attorney, making it even more difficult to try to do all the things that we've been advocating them to do. So thank you all for joining us today. Again, a quick reminder to come out to San Diego, come play with our small but mighty team. We definitely want to thank Casey Gwynn for the work that he's done in his leadership to really bring the criminal justice system to accountability, quite frankly, and creating that coordinated community response. We just realized that our San Diego Domestic Violence Council is going to its 30th year to celebrate the work that they've been doing as a community. I also want to thank Natalia Aguirre for having the nerves of steel. Technology does not scare her, intimidate her, and she actually embraces it. I want to thank Alexia Peters for being our managing attorney at the Family Justice Center and tackling many of these issues and creating some amazing programs, and Pam O'Leary for providing all the support to survivors and training a whole army of social workers and therapists on risk assessment, safety planning, and trying to get our survivors wraparound services. So for those of you who are on the call and haven't started a Family Justice Center, we have 2 books that will help you think about that. One is Dream Big, which talks about the history of the battered women's movement, where we came from, where we are now, and where we want to go in the future. And Dream Big, Start Small is the how to start and sustain a Family Justice Center. It's taking everything that we've learned from coordinated community response to that next step, to that next level, to continue the work that needs to be done. So thank you all for joining today's call. Special thanks to Stephanie and Marika for sharing their expertise. Have a happy Thanksgiving. We should have had one more polling question. Are you going to bake or fry your turkey? Let's see how many people do both, but that's for next time. Thank you all.
Hey, Gail?
Yes.
I just wanted to mention we had a chat question about the curriculum that was mentioned, and I think I was not chatting it to the whole audience. And we just wanted to say that that curriculum is called Strong Moms, Safe Kids. And they can find information about that on the DuluthModel.org Otherwise, BWJP also did a webinar on it, and that's posted on our website. So just wanted to send a shout out to that program up in Duluth.
Thank you so much. I'm glad you shared that, because one of the things about your presentation, it was just rich with information and resources and how to reach you at your 800 number, by email, by phone call, and just going to your website, which is it's a website that I frequent very often because you're always adding new information. So good work on all that you do. Have a happy Thanksgiving, whether it's fried turkey or baked. We'll see you next time. Thank you.
Bye.
Bye.